Security in homes and papers, that's what the Fourth Amendment is all about, and it prevents unreasonable searches and seizures. But there are some exceptions. Well, takes us to this week's case. It involves a real man, Kyle Tuschall, in Watertown, Massachusetts. There was a situation that arose when an apartment dweller called the police and said, "Ooh, I've got this really weird smell that's coming from one of the apartments here. It's making me sick. It's causing my dog to convulse, and I think something strange going on inside the apartment." Police showed up 3 days later, and when they came in, they found that in fact there was this unusual odor coming from one of the apartments. The owner of the apartment building had led them to the apartment. Long story short, people said that there were living in the apartment a man and a woman, a guy and his girlfriend, that they usually left in the morning together, but this morning they had not left together. The police obtained the cell phone for the woman from the apartment owner and tried to call her, couldn't reach her by phone, so they went to the apartment, knocked on the door, got no response. They entered the apartment, and when they got into the apartment, they searched it, calling out her name, never found her there. But what they did find were paraphernalia that was designed to make methamphetamine. Based upon that, they got a search warrant, came back later, found a bunch of stuff that was manufacturing methamphetamine. As they were leaving, the guy who was living there, Kyle Tuschall, showed up, and they asked him some questions. They gave him his Miranda rights, saying he had a right to remain silent, and he waived those rights, and he gave various incriminating statements to the police officers. Okay, he was then charged with manufacture of illicit, unlawful drugs. Case went forward. His attorneys brought 2 motions to suppress evidence. First motion was directed to the paraphernalia found in the apartment. They said no reason for the police to go into the apartment. Second was directed to the incriminating statements he made. Now, on behalf of the Commonwealth of Massachusetts, it was argued, well, one of the exceptions to probable cause and, importantly, to getting a search warrant is if there are some kind of unusual circumstances that appears there's going to be imminent harm. In this instance, we were concerned that there might be methamphetamine that was being manufactured and that there could be an explosion, especially if the stuff was left unattended. That could lead us to want to enter the apartment. The second reason was we were looking for the woman who we were told lived there. We weren't able to reach her on her cell phone. Therefore, we wanted to search the apartment to look after her well-being. On the other side, it was argued, no, hang on a second. One, there was no imminent threat of an explosion because you showed up 3 days after the original notification. Smells remained the same. Yeah, there was all those toxic odors that you were complaining of, but nothing had happened. There didn't appear to be any imminent threat of an explosion. With regard to looking after the well-being of the woman who you were told lived there, well, you called her cell phone, but you could have contacted her employer, saw if she showed up for work, could have done some other investigation without actually entering the apartment. And as to the incriminating statements that were made by the suspect, well, you only asked those questions because you had found the drug paraphernalia. Drug paraphernalia was found because of an illegal search. Therefore, these incriminating statements must be suppressed. Well, the trial court, when it heard these arguments, agreed with the defendant and his attorneys, said the evidence has to be thrown out. Well, the Commonwealth of Massachusetts appealed up to the appellate court, what is basically the Supreme Court of Massachusetts, and there the court looked at this, heard the arguments, considered the same arguments, and said, yes, you are right, Mr. Defendant. Your attorneys are making good arguments here. The evidence should not come in. It must be suppressed. Okay, so what do we learn from this? We learn a couple of important things. One, there are exceptions. In this instance, we looked at 2 of them, to probable cause and, in this instance, to having a search warrant, most importantly to a search warrant. We also see that the freedoms that are enshrined in the Fourth Amendment are very zealously protected by the courts. Okay, we bring you this case, we bring cases every week so you understand how the law works. I'm David Allen.